Today, I'd like to introduce two important people in this discussion on Kuleana lands. To my right is Alan Murakami from the Native Hawaiian Legal Corporation. And to my left is Mahoi Collins, also a Kalahui citizen, but he will be speaking on behalf of his ohana. And this is Mahoi Collins of Land Division, Department of Land and Natural Resources. But he's going to be discussing about the principles of the mahele. So can we give a warm welcome to our panel? Thank you.
I'm not an expert, okay? I want you to know I'm not an expert. I, like all of us here, we only know what we know. When we kuka, we discuss, we come to understand, we share our aloha, our na'au. So, and I'm just here. Number 3 is, I'm going to ask the audience participation. And first I want you to imagine, we're gonna be, for this portion of the presentation, we're all going to be decolonized. We're going back 222 years ago, we're gonna start. Because as far as Kuleana lands, I'm discussing Kuleana lands. Where did it come from? What does it mean? And how is it defined? So, 222 years ago, okay, this is before, Captain Cook had already arrived. You have about the time when Kaumoali'i, the kingdom of Kauai, comes together under the kingdom of Kamehameha. So, a kalai'aina, this is traditional, a kalai'aina, Kamehameha has a kalai'aina. So, as part of the participation in this kalai'aina, just pretend, no more genealogy, no more koko to Kamehameha, but I'm going to be Kamehameha, okay? And what I have, I'm going to pass that I need 5 individuals. And no more volunteers, I go and walk up to you. Okay. I'm gonna pass out these cards. Okay, these don't, to each of you. Just don't open it up. Hold on to it.
Yeah, volunteers.
Okay. Mahalo for participation. One more. Okay. Okay, so now, some of you have 1 card, some of you have 2. So you can open it up. Okay. Okay, and show me, okay, then, so I'm gonna start with her, okay? This is pretend the kalai'aina, because what happened in the kalai'aina was Kamehameha would give the authority and the jurisdiction to manage the resources of these ahupua and these ili. Okay, so as I, Kamehameha, allotted, Hollywood allotted, the stewardship of these lands to my kolahiki. Those of you who have 2 cards, raise your hand, okay? Oh, can you show me yours, please? Okay. Waiahole is the ahupua'a. So now I want you to give kaneloa to anybody you wish. Okay? Kaneloa is an ili in Waiahole. Who else has 2? And they are? Okay. You give pulama to whoever you, okay, so now, who else? Any more with 2? You, okay. Kahalu'e lu'ukoe. So you pass lu'ukoe, assign lu'ukoe. Okay. Now, I have one more. Remember, who am I in this mahele? In this kalai aina? The mo'i. Okay, so I have a hui manu, and I will give a hui manu to Alan. Okay, so all of you holding cards are konahiki. You are to manage the resources. The rest of us with no more cards, we are the maka'ainana living in these lands. These are, by the way, these are ahupua'a from, if you come from Kualoa, right over the ridge, oh, I kind of nervous, yeah? You gotta hear the air. But, okay, so, I gave, okay, as the mo'i, I had my kalai aina, starting from Waiahole, on the other side of the ridge that comes across with Pu'ukawai, Kiolea, Kuolani, the peaks. Waiahole on that side with Kaniloa. Then you come Ka'alaya. Then you got Waihe'e, and then you got Kahalu'u, and then the Ahuibanu is in Ili in He'ia. Look, okay, so, okay, now remember who gave it to you, okay, Kuruhiki, because in the mahele, there's two kinds of Ili, the Ili Aina and the Ili Ku. Now, it depends on who gave it to you that determines whether it's Ili Aina or Ili Ku. Ili Ku, the title stands alone at the mahele. The Ili Aina, the title went to the kolihiki of the ahupua'a, because that's how our kupuna did it at the kalai aina. Now, for the rest of us, Kuleana. Okay, we have Kuleana. Now, we all know Kuleana lands. But where does it come from? Kuleana don't only mean the land. Kuleana means the right or the interest that someone has in something or someone else. So, all us maka'ainana, we have a responsibility to what the land we take care. Yeah? Ooh, kalamai. I gotta breathe. Decolonize. Okay, so what we take care of, yeah, we have pahale, because now now 222 years ago, we never have cement, okay? We had pahale. Pahale was like a compound where you have your halemua, you have, I think, about 7 or 8 different structures for each purpose. You have your lo'i. So you're down by a kahawai somewhere. You have, I coming back to colonization, yeah? Maka'ari-ani. Okay, we got pahale, you got lo'i, you have mo'o, you have pauku, you have kihapai, and ko'ele, which later on comes to be known as po'alima. I talking too close? Yeah? Okay, so these are all our kuleana. At the same time now, we get konohiki, okay? And there are things like the loko ia, kita kahawai, that we all have to malama. It's not, not by kuleana, that's the government take care of. Let the mo'i take care of that. Aole. So our kuleana is the whole of the aina with the whole of the people. So these are the kuleana lands. Now comes that we all have traditionally, by our kupuna have, then comes, coming forward in time, you got the mahele. Now, The mahele is when private property rights start come into effect. So, what are we as the makainana? What we have to do, what the process was, is that we lay claim to the lands we taking care of. Laying claims means first we have to register our titles or register our claim. It's called the claim at the time. Upon receipt, well, the Land Commission is established by the 1840s, I believe, 1845, yeah? And the Land Commission is established, and then there's a set of rules which are in the principles adopted by which they are to determine ownership, private title. What they do first is the kolohikis and the king, we all sit down first. We have the mahele, first part of the mahele, and that is me with my kolohikis. We exchange, we give up our interest. Okay, we start to divide the interest because what the Land Commissioners, what they did was they found that this aina, this Hawaii, all of us, the mo'i, the kolihiki, all the kolihiki, and all the makainana, we all had interest together. We all had kuleana together. And together we malama the aina. We never point finger and say, not my job. The aina is our kuleana on every level. But now we're going to have private property. So we have to, it starts off by like the kolihiki and the mo'i, remember the third, and all these kolihiki, about 286, 246, I'm not sure of the number. We start dividing our interest. So I give you kahalu'u, I give you kahalu'u, I give you what you have. Yeah, ahui manu, I take back. Okay.
You take that.
Ahui manu is crown land. It becomes crown land at the mahele. Okay. But in the meantime, the makainana is still on the land, still working the land, still taking care of kuleana. So now, one of the processes is, if you want to own your land, first you claim it, you register it. So you register it with the Land Commission, Land Commissioners. Upon the receipt of your claim, they assign a number. So it's called you got helu, the number helu, and whatever by the order it's received, you have a helu number. You have a Land Commission number. Then the commissioners would go around the islands and would then have hearings by which all of us makainana would testify as to how we got the land, who gave us the land, how we using it. And so then the commissioners would, if there's anybody challenging it, any other private citizen that's challenging your claim, your kuleana claim, then they're not going to award you that, because until they determine who has what they call the calamai, I'm so nervous.
All right.
Yeah, you register the claim, what they call the general principles. And this is all in if you're familiar with the indices of awards or the index to all the Land Commission awards, it's in the front, the principles adopted. And so, and I thought I was so organized. Okay, okay, right here. Okay, so, so what they had to do was they looked into how you obtain the property. Okay, if you got it from the king, before 1839, or his representative or his agent, and then all the commission would ask is to how your claim is derived, meaning how you got it, who gave it to you. But then if there was a challenge, then you would have to, the two would have to bring more evidence. And then upon the evidence, the land commissioners would adjudicate or decide who had the title. So then you have your land commission award number, your Kuleana Helu number as adjudicated. The Kuleana had to be surveyed, and so what you see on the award is a little sketch, and you see there's a signature of the surveyor, the date that it was surveyed, the Kuleana was surveyed, and that's that. But because the title that the commissioners could adjudicate was only to a lease or a fee lifetime, yeah? If you wanted to change the tenure or the tenancy by which you held, then you paid for a commutation fee. When you paid the Minister of the Interior, I think it was 1/3 the unimproved value of the award. And on every Kuleana Helu, you could see a $3 sign, or $3, $5, whatever it was. So 1/3 of that value was paid to the Minister of the Interior, and then you had, then they issued you a patent, a royal patent. The royal patent confirmed the tenancy of a fee simple absolute, by which, when you passed, the title did not escheat or go back to the Kuleana owner, the Kolehiki or the Ahupua or the Ili owner. It stayed in your family, you could pass it. And that law lasted for about up to 1850. Then, in 1850, August 6, it was, regarding Kuleana lands, I guess the Hawaiian government was getting to the fact that the Kolehikis were also paying commutation. And in the Kolehikis paying the commutation for all the lands that these Kuleanas were in, then the Makainana no need pay commutation. So from 1850 to the end of the commission in 1855, 56, I believe, all of those awards were issued free and in absolute fee simple, free and clear of commutation to the government for any changing of tenancy, yeah? So that's pretty much what the Kuleana lands are, and how it came to be privatized. Any questions? Yes, ma'am.
Do you need a docket number to prove that is your family's Kuleana land?
Okay. Well, okay. Now, when you say to prove it's your family's lands, then you're because I just went up to the, remember now it was 220, well, to the Mahele, yeah. So like, we was decolonized, never have any of that kind of laws and all that. So, the proof that you would have is the land commission, or what they call the land commission award, and the royal patent issued in confirmation of that award. So when we come forward in time, a lot of times we have to, he's going to talk about the quiet title actions on such lands, and what we would be most beneficial is that, number one, we know our genealogy and the chain of title, because it's private property now, say 1855. So now that's 100 plus years ago. So you want to make sure that, one, you are related and you got your documentation to the relationship, and number two is you have because the court's going to rule on the ownership, so that you have the chain of title that links to your lineage. Yes, sir.
So who has, if the, your ancestors got the oil pattern or the oil spill, the legal conversation? Because there's a lot of families out there, because you can look at the indices, you can see the range on what would disqualify a Hawaiian today from actually having or still being heir to the land? What would have needed to happen in order for them not being eligible, basically? For lack of a better word, but do they are they here just because they're a descendant of that person, or is something happening over there sometime here? What would basically say you no longer have
The rights, the Kuleana rights are attached to the land. So it can never be taken away. And in 1848, with Kamima, when he went from all the Konehiki lands, the government lands, and the king's lands, or the crown lands, by some law in 1848, June 6th, I believe, that was every ahupua'a and ili was made subject to the rights of the tenants. The rights of the tenants are attached to the land within the ahupua'a or the ili. And so when we're coming into as heirs, now legal heirs is genealogy, but then now when interest and title to the land is in the documentation of how the first awardee, we call him the awardee, the guy that got the kupuna that got the Kuleana, say, then you can be an heir to that person, but if our kupuna deeded it away 100%, then that would mean that we are the heirs, but we don't own the land by the document of the deed back then. Okay, that's how the courts are going to rule. But I think Alan can address all of this, yeah? Because he knows the law. I just studied the Kuleana. Okay, so, yes, ma'am. Did I answer you? I'm sorry? Okay. What office? Okay. From Kayulani, viewers can date. And from the land office upstairs where I work. Yeah. Sir.
As you're saying, your genealogy is an important step. It's probably the most important step. From a Papa point of view, I think a lot of Kanaka are at the point where they understand and can prove their genealogy, and we're now coming to a point where we know where our lands are, and we're discovering that there is undivided interest pertaining. I think the biggest question would be, myself included, would be, how do you take it from, what is the next step? Where is there legal representation that would allow access for regular Kuleana landowners that aren't really able to hire Alexander and Baldwin or Carl Smith involved? That's pretty much the #1 adversary I see. Kamehameha Schools is another big person sitting on a lot of Kuleana lands. Where do we go in terms of Kamehameha Schools? Is there a land asset manager that we can speak to in terms of somehow coming correct with undivided interest pertaining per lot? I guess my big question would be, how do you take it? What's the step to go from paper to activation of reality? You know, how do you go from studying to planting without bothering by the police?
Yeah. And correct me if I'm not answering or addressing your concern. The operative is, okay, you want to know about the undivided interest. Okay, my understanding of undivided interest is like, let's say I have 10 children and I got me a Kuleana. Okay, I claimed the Kuleana, I got the Land Commission Award. So then, what I do is, I give it to my 10 children. Okay. Now, that means that each of them have 1/10 ownership in this Kuleana, but their ownership in this Kuleana has not been subdivided, so it's anywhere within the Kuleana. Okay, that's one. Now, maybe 5 of my children conveyed out their interest. But you can only convey what you have legally. So each child can only convey 1/10 and sometimes the document, the Pala would say all of my undivided right, title, and interest. But if you know your genealogy and you know that, say I'm your kupuna and you know I had 10 kids, then 5 of them that conveyed their undivided interest, that already went out. So they're coming down forward in time, their children, grandchildren, and their lineage don't have any title to it. But they're heirs to me nonetheless. Because this is quiet title action, so it's just went out. Now there's the other 5. So the remaining 5 of my children all now have an undivided 1/5. Well, not really one fifth. Am I right? Well, there's
5 out of 10, yeah.
yeah, they have half. Between them, they have half the interest. But whoever's the other half interest already got sold out. So that's another chain of title that is not, the ownership is not in my heirs. This one would be. So when you come forward, and I'm going to lead into Alan now, when the quiet title action notice appears in the paper, you notice that there's kupuna we realize, we acknowledge, and we know these names. So we have to come forward and answer and respond. And the reason why their names are there is because some big company or whoever's the plaintiff, or the one bringing the action, the plaintiff then had some big company like Title Guarantee to research. And that research found breaks in the chain. The breaks in the chain of title refer to all these names in the paper. So that means there is ownership to the names cited, in the recitation of that notice, yeah? And then it gets into court. And how do we get there?
Maybe I should pick up on that answer to that question. I'm Alan Murakami. I'm with the Native Hawaiian Legal Corporation. We were born as an entity out of the days of the initial occupation of Kaho'olawe before I got there. As we evolved from a coalition of Native claims to a Native Hawaiian Legal Project to the current Native Hawaiian Legal Corporation, which was a formal, recognized legal entity, we had to get funding. And as a part of that funding, early on, the original director of the corporation was Boyce Brown, who some of you may know. He fought H3 for 20 years and held him up until Senator Inouye passed an exemption of his lawsuit and got it built. But he was the original executive director, and he made a pitch to the Office of Hawaiian Affairs, and a critical part of that proposal was to do what we now call quiet title defense work. And it involves the kind of questions that you're raising about how do we prove in court that a Hawaiian family owns that property. And it's not easy. I'm here, and I'm going to recognize Edie Fukumura over here, sitting over there. She's one of our office heroes because, frankly, we couldn't do our job as attorneys without people like Edie. And see, so now they're going to ask you all the questions, Edie. Because she is focused on doing the research. That includes both at the Bureau of Conveyances, which Kayu is the queen of. So you can go ask her questions too. All the Palapala is there because it's a central registry for all the deeds that exist for any piece of property out there that is recognized. That is what they call the notice to the world. If you want to find out about whether a deed was created and then signed and executed and then recorded at the Bureau, then it's there. So you can find out the history on the Palapala by going there. But you have to do this research, and it's intensive research that's not easy to do, frankly, because you can miss stuff. You don't know where to go. You know, the very question, where do you go? That stumps a lot of people right there. But people like Edie and others that do this research day in, day out know where to look and what questions to ask, what papers to look for, and how to find it. Because even if you go there, there's a system that they have through the indices that allow you to go and figure out how title got passed down by paper deed from grantor to grantee over the 150 plus years since the Mahale. So that takes a lot of doing. And, you know, half of that stuff is in Hawaiian too. So you got to know your Hawaiian. And these researchers that we have in our office are specialized in that. The other point I want to make clear is that would be the easy part, because you can trace it by paper. If you know your great-great-grandfather or grandmother was the original awardee, and you can trace it down through this paperwork, grantor to grantee, that grantee becoming a grantor to grantee, and so forth. It's what we call a chain of title. That's an easy way to find out if you got that property. But I don't know, Edie, how many times out of 100 would you say that chain on paper doesn't exist till today? Because frankly, a lot of people didn't deal with that on paper. You know, we came from a system of collective malamaina of the property to private property, and you know that's a massive change. What we lost in that process, in terms of the creation of this quiet title, was the former, you know, mutual relationship between Konohiki and Makainana to Malamara land. You frankly couldn't stay on that land unless you made productive use of it. You farmed it. You raised your family on it. You gathered from the mountains and fished at the sea and gathered limu at the sea and made your home there. If you were just like, you know, sloughing off and doing nothing with it, in that mutual system, you could lose your rights to occupy that land. But if you made productive use of it and was industrious and, you know, provided for your family in a variety of ways, nobody really disturbed you as a general matter. And the Konihiki was able to manage the system in the Ahupua'a like that. And you got kicked off if you didn't do what you were supposed to do, like, you know, help manage the awai so that the water would come to your land, or plant farms that crops so that you could feed your own ohana. We lost that with the private property system. If you had a private property as a konihiki, let's say, and you didn't do your job like you did in the old days, it didn't matter. Private property meant that you kept title to that land. And there's something really, it's a massive change in the social system if you think about it, because what was a once sustainable, productive system of land management by the Konihiki and the Makainana, living in kind of a mutual relationship. They depended on each other. To one where, oh, you know, I own this land no matter what I do. That's a big difference. So just keep that in mind. It caused a lot of social disruption. So you can trace, as I get back to this question, title from property owner to descendant by deed if it exists. Okay, oftentimes it doesn't exist. And that's where genealogy comes in. And Edie and others like her do that as well, because the laws at the time provided for how someone who holds property or title to land and dies without a will and without a deed that he or she signed, those 10 children that Mahoi talked about then have rights through what we call in the law intestacy or inheritance. And there's formulas in the law as to how you take that property. The children, of course, take it first, and maybe the spouse for a certain period of time in history. But that formulation then passes down through time. And then you got to go through genealogy to figure out, well, how much of it passed through time. And maybe the son or daughter of the first grantee had 9 siblings, like the 10 children, right? So you're only talking about 1/10 now of your ancestor who came from that son or daughter that passed down over maybe another 3 or 4 generations. So you can imagine if you do a tree of what happened in the genealogy, how tiny your interest is if it's just passed down by genealogy, much less by deed. So it creates a huge problem because you can imagine what kind of conflicts can exist or can erupt from the literally sometimes hundreds of people that are left with title to a 0.5 acre Kuleana. How do you resolve the questions of ownership? How do you resolve the question of who pays the taxes? How do you resolve the questions of who gets to stay on the land? Much less knowing whether or not you actually have a percentage interest in it. So, short answer, and there are many other parts of this answer that can be more detailed, but you can trace it through the conveyances that are available in documentation at the Bureau of Conveyances, and or the research you do in genealogy to see whether or not that interest passed down, absent now any deed in between by any of your ancestors that he or she might have deeded that property out. But
Sorry, I have a follow-up question.
sure.
All very good information. I've been blessed to have been made it down to the Bureau of Conveyances. I've actually spoken to your office. I've spoken with Grace. And somebody had called me back, but I have been playing an unfortunate game of phone tag. I've been waiting to speak to you guys because, as you say, I actually was waiting to come to you guys today because I bought some paperwork certified from the Bureau of Conveyances. And the reason I come to you is because this is actually concerning 24,000 acres in Mahoi. My family, we have the chain of title. I'm actually listed on the TNK. The operates. This is our chain of title. This is pertaining, the reason I speak to this is because it states the undivided interest of Dan Robinson is there are only less than 4% in undivided interest in our lands. These 2-3 parcels pertain to my family. So instead of me going there and trying to just hold it down, what my concern is with a major law firm is this deed certified from the Bureau actually showcases 150 families that are 96% owners of Mahoi land. So instead of me just returning and hiding in not hiding, but creating like I've been trying to reach out. How do I with this whole, because I feel like, everything's there, get the leases, yet one major issue if you ask me, because what they did was with their 4%, they leased their land to themselves for $109 million per parcel, or per the area. So my big question is, A, as 4% undivided owner and 96% owner, am I not entitled to 96% of that said lease of the land? B, as 96% owner and not 4% owner, wouldn't a majority landowner have more rights to his land than a minority?
Okay, I got multiple answers for your one question. Okay, first of all, you have a co-tenancy, it appears, if in fact it's true you have this parcel. Okay.
Yeah.
But the first thing I have to say is this is an order of accounting and distribution. It's a probate matter. Okay.
The follow-up, that's how they actually acquired it. See, what happened was, Dan Robinson was a housekeeper of my papa, and after the estate had passed, they liened the property through housekeeping fees and then lawyer fees, which created the estate to dissolve itself by payment of INA for housekeeping services. But through my great aunt's Coco, they acquired all her undivided interest, 4% in 150 parcels of Hawaii. So that's where I don't understand it. If you look it up in today's current TNK map, it still shows Dave and Robinson Court and klhpoliticalactioncommittee Kuleana. I'm not the direct descendant of klhpoliticalactioncommittee Kuleana. There is no other way to disprove this. I get everything inside that book.
Okay. These kinds of questions come up pretty often, okay, because they'll find an order of distribution like this that affects one person's estate. Somebody died here in your, I don't know if this is in your lineage or not. But an order of probate is to determine who the heirs of a decedent are and to settle accounts through whatever debts he had and whatever assets he has. And then the heirs get that share after this order of distribution. Frankly, it's technically not a determination of title. It's not. Okay, because it's different from that. This tells me who the heirs of Ruth Field are, and AKA Ruth Robinson Field. This is a court saying we've looked at all the evidence, and Ruth Field had this many heirs and who they are, and what I can take from that estate. It does not say how much of the property was owned by Ruth Field and how much their heirs get in percentage interest. And it cannot be that. Okay, that's a different proceeding, and that's why we have two brochures that may have some relevance to you. It's in your materials. One is the question of co-tenancy that describes what your rights are as co-tenants, whether it's tenancy in common or joint tenancy. The second one is about a quiet title lawsuit, which this is not. This is not a judgment in quiet title. Yeah, yeah. And what I'm saying is that this is only something that will inform the world who the heirs of Ruth Field are. It will not say what the true owners are of the properties that may be listed in this are. It's different.
Yeah, but you know what I like to ask is, what if the other family that had interest, they give that land to somebody who's not even Ohana, not even Koko, not even, not even have the name from, never even was a direct descendant, and they go and they make one quiet claim. How'd I go?
Okay, let me see if I got your question straight. You're saying a stranger to the genealogy writes up a deed and uses that deed to mention one of these properties and gives a deed that to somebody else.
Yeah.
Okay.
What I'm saying is a family member who is a direct descendant gives their interest
Okay.
to a total stranger. Yeah. And then that stranger go and get one quiet claim title. Does that person that goes and get the claim title owns that whole Kuleana land?
Okay, I gotta go back. I gotta go back to ask the question of what your question is. You're saying that the person is a descendant of the original grantee?
Gives the person who is a
relative
direct
conveys
descendant gives a person their interest to the land, but is no relation, is no more coco, and then that person who got that what they call it, the grantee give the grantee,
The deed.
yeah, whatever that part.
It sounds like
And
a
then
deed.
that person
Outside of
gets
family.
to go in the newspaper, get the quick claim title and all that. Or you can buy it.
Okay.
Buy it.
Okay.
Quick, yeah, quick.
I would have two answers for you because, but I'm not sure which one would
Sell,
apply.
how you sell? She can sell.
Oh, okay.
Okay, from the LCA, one of the authorities, they went to the father, a tiger. From there, went to the next, but never mind. They needed, not quick, or quiet. Quiet, they made a quiet, quiet is which is quick when you just go and give somebody a possession to use the land. So I cue you quickly, that I give you permission to be the groundskeeper. But over the years, we have occupied. And now they bought on other people now. It's a corporation that's there. And they're the current tax owner.
Okay, this is,
But yeah, see, I'm telling you, quit and quiet is different,
Yes.
right?
and quit claim may be different from a lease. I'm not sure what you're talking
No, but
about.
and when you go to the Bureau of Conveyance and you register your name, that's a quit, right? QUIT, to occupy the land.
Wait, let me
It's
get-
not a quiet title. We didn't go through a quiet title.
What happened with her situation was her uncle was a generational crossroad. She's a descendant of the original landlord.
Okay.
From the Mahoi.
So she's within the genealogy.
Yeah, she's in the genealogy. She has an uncle.
Yeah.
Who basically gave permission, is what I said. I don't know how he gave permission. But he gave her permission for this non-Hawaiian entity to go ahead and use land on Maui. So here we are today where she's doing her research and everything, finding out that that's the case. So now, what was actually given to this entity? What was she's an heir, he's an heir. She's a generation year old. What did he actually give over, and what rights they had that did not give any of their interest in the land over? But now we have a situation where they pretty much have physical domination over the land right now. Based on what her uncle gave, which was basically, from what I understand, just his interest is in there. What happens to the other family members who still have an interest, or still heirs, but now we have a situation where the land is being claimed by another entity?
So let me make sure I understand the question right. So the uncle and you are in the genealogy of the original awardee, correct? So your uncle is obviously not in your direct line, but because your father was, or is it your mother, was the sibling, right? Okay, so I don't know what your uncle gave because I'd have to see that paper, first of all. But if I assume...
You guys get them. I sent them all $90 work. I faxed them to you guys. You guys give me a run around. You just call me back.
Okay, wait a minute. I am personally not aware of what that looks like. Okay, so, but if I assume that that was a deed and it was a good deed, then your uncle's interest was deeded out, like Mahoi say, as an example of the kind of thing that happens oftentimes where a member of the original awardee's family, descendant, deeds his interest out. That goes out, okay, of the family and is not, at least in our current legal system, recognized as title anymore in his name. In your father's line, if there was no such deed, then you retain interest in title to that same property if you in fact can tie into that genealogy. So it would not affect your father's interest and therefore not affect you if there was no intervening similar kind of deed that your family line executed. Okay? I can tell you that much.
Going back to page 2. Okay, from the LCA, the deed made a deed to the son. From the son, it went to, he has 13 children, went only to 5 children. Now, if you don't belong to that deed, now all the other children are claiming, only 5. So who has the correct heir?
Okay, so assumption is original awardee deeds to the son, 100% of the interest, right? Son deeds to 5 out of 13 children. Again, in a deed, right? Just to 5 out of 13, right? And your question is what happens to the other 8 people's interests?
Kuleana and, the 5 children.
I'm sorry?
The 5 children who was deeded the land, didn't do their Kuleana as to take over the payments or follow up, even as today.
Okay.
So other family members have, come in, the other children.
You mean of the other 8?
Yes, yes.
Okay, and your question is what happened, can the other 8?
Yes.
Oh, okay. If it's true, the deed went from original awardee, 100% of the interest, 100% of interest to the son of that person. If is a valid deed and it's recorded, that is a conveyance to that son. If that son turns around, makes a similar valid deed, and these are questions that come up in law all the time, whether it's valid or not, and deeds it to 5 out of 13 children, 100%. So it's now 1/5 each, right? They have a 1/5 interest in that Kuleana each. That excludes the other 8 from being able to claim it. Okay, that is what the system of our laws on what the effect of deeds are. I mean, I can answer it simply that way, but I have to caution you. A lot of times, people bring us these kinds of conveyances they think that exists, and we find errors in what they're saying. Okay, I'm not just trying to say you have an error. I'm just saying that in our experience, that oftentimes happens, and Edie and others have to go back in and corroborate what happened from what people are saying, and something, I don't know what percentage, but not an unusual amount of time, it's not exactly as what was represented to us in the beginning. So that's something that has to be verified by our staff if we're going to take that position on behalf of family. The other thing I want to say about this is that these questions about title that affect Hawaiian families, there are thousands of them, okay? And there's hundreds of thousands of questions about any particular conveyance. As a result of that, you can imagine that if our office tried to address each and every one of them, we would not be able to do our job. I mean, that is just a plain fact of the matter. Yes, we get money from the Office of Hawaiian Affairs, but that amount, for good or for bad, or whether or not that's adequate or not, that's a fact. We have an X amount. And we found that we, at least in the past 40 years of our work, have found that we can only focus on those kinds of claims that have already been brought to court, usually by some larger non-Hawaiian entity trying to quiet title of a piece of property. This is in your handout, by the way, so that they can have certainty about their holdings on a piece of land after the judge determines, either agrees or disagrees with what they say they have. If they agree with the landowner what they have, then that landowner, usually non-Hawaiian, can take it to the bank, and they generally want to take it to the bank because they want to borrow money to develop the land. Okay, and that's why, at least in our first, 25 years of our history, Edie, a lot of our quiet title actions was coming from Maui. We hardly had anything from Kauai, and then maybe a handful from the Big Island, Kona side usually. Oahu was already developed. But you could see it in the nature of where the lawsuits were filed, on what lands they were trying to affect. Maui was heavy, West Hawaii was heavy, sometimes East Hawaii, because there's huge chunks of land there owned by the big estates and ranches. Some on Oahu, but frankly a lot of Oahu was already developed to an extent where title was not at issue. And a lot of commercial properties were already established in terms of what the interest of the title holders were. Now the other thing, the thing here that could be another qualification on what I just told you, that you may still have an interest, is a lesson I learned because I started off my practice on Molokai. Anybody here from Molokai? Hello. Donna. Oh my God. Sorry, Donna. Too many years. Okay, and that's where I had my first taste or flavor of what we're talking about here right now. Walter Reedy, I had the first taste of him too. Unfortunately, the lesson I learned on Molokai was a bad one, because we took a case of Antilani Kapuni, and we lost it to adverse possession. And I raised that lesson to you because that could be something that interrupts anything I've said. It could override what I just said to you. Because if somebody in your title did not take care of the property, as you were mentioning, but in your line of title, and some ranch, some corporation, some estate wanted to use that land and started to use that land without any rights, but they kept using it, and nobody in your line challenged that in court within 20 years, that can become what we call adverse possession. That the court will say, oh, because you weren't diligent about stopping that much bigger estate, much bigger corporation, much bigger whatever, landowner, from continuing to use that land, you lost your rights to the legal title. Largely saying legal stealing, because the court's saying, well, it's more than squatters, because after 20 years go by, that's a good question to ask. So, if that adverse possession is successful, it will interrupt even your valid claims, whether by deed or by inheritance. Okay, so that could really throw a monkey wrench into what I've just told you. And thankfully, in the 1978 Constitutional Convention, there were limits put on adverse possession, including how often you can do it and how much land you could do it at any given time. But it was only going forward. So the 20 years that had passed for adverse possession to work on anybody's particular title that had already occurred could not be disturbed. Okay, but it's something. Going forward from 78, there are limits to adverse possession. And so far, I think, Edie, correct me if I'm wrong, that ever since then, the adverse possession claims, even the ones that were mature, so-called matured, that we fought against at Native Hawaiian Legal Corporation, we've been able to successfully defend against. Because, frankly, we were able to put more resources into defending those claims. I was just a single person, legal aid attorney on Molokai, trying to do all this research and gather all the evidence, and it was hard. It's very hard because some of these larger landowners, they have much more bigger resources to get witnesses, testify about what happened in the past, whether or not anybody tried to challenge them. And in my case with Antilani, it was not successful. However, there was a ray of sunshine that came out of that loss, and what we got out of it, even though ultimately Antilani did not retain title to that Kuleana, the court in the appellate court, where we could not get the title saved, said, hey, they made a pretty important procedural decision. They said, hey, even if you try to do this in quiet title actions, we're going to hold you to the letter of the law on who's given notice about that lawsuit even being filed and your opportunity to defend against it. Because what was happening back then is that they would do these really quick and dirty searches for people who may have a title to that land that get named in the lawsuits. And they would just say heirs of the original awardee, not your name, but the heirs of the original awardee. And unless you saw that in the paper, you wouldn't know. And what they were doing is that they weren't publishing some of the stuff in the Advertiser or Star Bulletin. They're publishing in the Hawaii Hochi and, these really, because all it said was that it had to be published in a newspaper of general circulation for X number of weeks. And people would miss it. And so you'd never get the opportunity to go to court. So that got changed and it got more rigorous. The court would kick out lawsuits because they weren't diligent about trying to find you through the proper channels. The records at the city, the records at the Department of Health on genealogy. The court forced these plaintiffs to go forward and actively look for people who could still be alive today. And that was a real benefit, I think, to a lot of our future lawsuits because we got to represent the people who finally got notified, who got actually served by a sheriff personally, and then as a result got notice, hey, my land might be in trouble, I better go do something about it. If you didn't see it in the newspaper, you wouldn't even know. Sometimes people don't even know they own a Kuleana or a piece of property. So that was one blessing in disguise, silver lining in the cloud that happened from that lawsuit. Anyway, enough of my commercial.
From Molokai, concerning what you're just talking about, State versus Pettigrew, 1995. I believe they discussed in that case, isn't that a case law that you could cite about heirs being publicly notified but not heirs of? We're trying to read through State versus Pettigrew this week. So
1995.
Yeah, isn't that, and then there was like the appeal court in 2004 or 5 is when the final.
Oh no, see, the case I'm talking about was before that, so it probably relied on Hustis versus Kapuni. Okay. The rancher Hustis that was living on the island adversely possessed that Kuleana against my client. But the result of that appellate decision is that you have to be more diligent about, and you have to satisfy all these requirements to find people alive today that are related to the original awardee. So I'm sure Pettigrew is cited that case, but I'm not familiar with that particular decision. Because this was a 1980s case that got decided by the Court of Appeals. Yeah.
And I think I might have emailed you a little bit about this, but about 4.5, 5 years ago, I did a move against Mahoi and Klein. I had done some title search work for someone in the area in Honolulu and Honolulu. And as we go, when we're doing these things, we are continuously guided from the other side what to do, what not to do. And if you're paying attention,
Could you specifically reference 172, 11, and 12? That's something that I work with. Okay. And that is specifically to the patents issued in confirmation of an award. So when the patent, okay, so remember, first you get the awardee, the claimant is adjudicated the land, the Kuleana, and a land commission award, and then to compute or to change the tenancy from life estate to absolute or fee simple to pass to the heirs, okay, a lot of times it didn't happen right away. But where the award confirmed, or the award granted the title, the patent on the award confirmed the tenancy. So those two statutes that you refer to, that, for instance, there are many awards that have not been confirmed under the patent. Okay, so, and the changing of the name, number one, is contingent upon the time of the issuance of the patent, which means that up until 1893, royalty existed, so it was the royal patent that was issued. After 1893, what confirmed the tenancy of the award is the land patent. Okay, so, and my understanding of it is that it doesn't matter who has the title, because the government is not confirming who has the title to the land presently. What it does do is that the award that's issued under the awardee's name, the patent confirms the tenancy that was alienated, and the alienation is that you're going to hold it on your own, free and clear of commutation, and as well as this allodial title. Now, way back 222 years ago, the way they understood the holding of all of the lands that we all had in common, okay, were once, because we no more private property, we don't own them, we have Kuleana in it. But when they decided to introduce private property, we had to separate the interests. But the way we lived 220 years ago, the allodial title, because they, okay, gotta think, like a little bit weak, a little bit confused, but you gotta think that our kupule came from a system that was nothing to do with I own the land and it's mine. It is everybody's. Everybody has a Kuleana in it, and everybody's going to take care of it. But now comes the mahalo, and now we got private ownership, and our responsibility, our Kuleana to it, is all Hollywood codified or into the laws. Not my Kuleana for, if I see the dead cow on the road, not my Kuleana for clean them up. That's the government got to do it. 222 years ago, the people living and using the Aina, they just go and jump in and clean them up and no worry. Yeah, but complicated now with laws. So anyway, as far as the allodial title is that, if you look at a lot of the awards, they're going to say that the phrase is mahalo oke ano allodial. So less than fee simple. And then in the patents, it says make ano allodial, fee simple. So that it's the ownership that changed. And the inure means that the patent is going to make reference in the name of the awardee. Yeah? I answered your question. Okay, mahalo.
What is the royal patent supersede?
What supersedes what?
The royal patent has to supersede the new patent is coming out.
Does it supersede what new patent coming up now? Because you're gonna have a royal patent, and that's how already for the award. If for those Kuleana that are, that the government issuing patents on, that patent, that pala that's being issued is really is evidence that the commutation fee has been paid and that the tenure has been changed. Now, so it doesn't supersede, it doesn't supersede. And you don't, generally you don't issue two passes on the same award unless some people, that the government allowed for portions of the award to be patented. So depending how many portions the award has, you're gonna have, you may have as many passes.